the matter of Palladian Partners LP and others, and the Republic of Argentina and another. Part heard.
Yes, Mr. Elton.
Good morning, my lords and my lady. When the court rose yesterday, I was addressing the judge's consideration of various economic arguments.
Yes.
And in particular at that stage in relation to paragraph 206 of his judgment. And just to finish the point, if I may, on that, I should show you the experts' agreement as to what certainty the parties would or would not have had in advance in respect of level and growth on the rival constructions. And that is in Supplemental Bundle 3, tab 47, page 114. And this is the experts on GDP-linked securities. Page 143, in particular, paragraphs 16.4 and 16.5.
114.
So 114, my lady, I'm sorry. 16.4, the claimant's interpretation produces a predetermined known base case GDP levels and growth rates for future years in the 1993 year base prices. It does not produce a predetermined known base case GDP in any new year of base prices. And 16.5, the Republic's interpretation produces, after the overlap year and until any further rebasing, predetermined known base case GDP levels for future years in the new year of base prices, and preserves the same growth rate of base case GDP implied by the base case GDP level data for 1993 year of base prices specified in the securities. Then you'll see in 16.6 there's a short exception in relating to the timing of the year in which the change takes effect. Now, it is irrelevant to the actual construction of the adjustment provision, but in light of certain exchanges yesterday, I think I should make clear that the Republic did not in fact publish any revised base case table following the rebasing, and indeed didn't calculate at the time what it considered the adjusted base case level to be. And that was simply because, picking up on my lady's questions yesterday, the growth condition, in other words, the performance condition on whatever fixed fraction was applied was not satisfied, and the level condition, as my lady anticipated, was satisfied, again, on whatever fixed fraction was applied. And it's also fair to say, as you may have seen from the skeletons before you, that the Republic didn't nail its colours to the mask of 2012 being the overlap year until this litigation. But that is the year that we say the adjustment provision engages on its true construction, and we're either right or wrong on that. Now that was picking up from paragraph 206 of the judgment. The second point made by the judge in this run was in paragraphs 207 to 210. And the point that he was raising here, or addressing here, was concerned with, as he put it, the concept of non-linearity. And the underlying point, as we covered yesterday, being agreed between the parties. In other words, because they are using different parameters to measure the economy, there's no linear relationship between actual real GDP or actual real GDP growth in one year of base prices to that in another year of base prices. That's common ground. But the respondents were relying on this as a further reason to stick to the base case and growth rates applicable to 1993. In other words, it is, as we understand it at least, and we believe the judge understood it, another aspect of their uncertainty argument. And of course, if we're right in our point that the growth rates in the base case table are not tied to the 1993 year of base prices, but are real growth rates, whatever year of base prices applies, then the point goes. But what the judge is addressing in this part of the judgment is our short point that non-linearity doesn't relate to changes to the real world economy, just to the different measurement of it. And you see his reference to that at the end of paragraph 207.
Is there a distinction between the two?
Is
there a distinction between the two? Is there a distinction between real world economy, measurement of it?
Yes, indeed. My lord, the real economy is what's actually happening in Argentina now.
But it's a function of measurement of it. It may be an absolute concept, but any expression of GDP to represent it will only be an estimate, won't it?
Absolutely right. It is an estimate, and the most recent and updated estimate will, as the judge found, be the best of the true economy, or the real or actual economy, as he described it. But the point is, when you're looking at the question as to the economic input, non-linearity tells you that if you've got two different measures, there's going to be differences between them. It tells you that the measuring is different. It's not actually making any difference to the underlying economy. The underlying economy is what it is. And it's a short point that simply the relationship, the fact that you have different measures.
You can only address what the underlying economy is by some measurement of it.
Absolutely.
And if it makes a difference to the measurement of it, then in that sense, it makes a difference to what everybody regards as the real economy or the true economy.
Well, the question here is whether the relationship between different bases is economically relevant. And our submission is no, it's not. It's telling you that they're different. And as my lord says, well, they're different measures. You've got to make an estimate somehow. But you end up having done it in 1993, then in 2004, they're different. The fact that they're different, what is economically relevant about that for the purposes of this argument? And we say it's not economically relevant at all.
Sorry, so is your submission that the difference between the different bases is not economically relevant because neither of them represent the true economy?
Well, what we do say, and my lord has our submissions on this, that the most up-to-date measure is the best measure of the real or the actual or true economy.
I understand that.
But the fact that there is another measure which has a non-linear relationship to the current measure, what is the economic relevance of the fact that there is a non-linear relationship between those two measures? In our submission, the focus should be on the core economic point, which is going back to what the judge found. The underlying purpose and objective is to use the best measure of the economy available. In other words, the rebased measure. And just picking up in paragraph 209 on page 139 of the judgment, the judge acknowledged his earlier findings in relation to this. And you see that picking it up in the third line, after Mr. Valentin's, he refers to Mr. Valentin's submissions relating to the real world economy. And the judge said, this he observed is consistent with Dr. Brita having agreed, in line with what I have myself already agreed, that the purpose of the securities was to pay out when the real economy is growing at a healthy rate. And so with the need to adjust base case GDP in a way that makes it comparable to the best measure of the real economy. Now that also picked up on his earlier findings that I showed you before in paragraphs 76 to 78. But the judge then in paragraph 210 dismissed the economic significance of that by saying that the adjustment provision looks at something else and not economic performance in the abstract. But that in our submission is simply ignoring the obvious economic importance and sense in the adjustment provision reflecting the most up-to-date measure. And the judge seems again to be excluding the relevance of that because of the decision he has already made as to the meaning of the clause. And you see that halfway through the paragraph, he refers to in its own terms. Sorry, this is in paragraph 210. Now that paragraph then finishes with a quote from Dr. Boyter's evidence, which seems to us simply to be a non sequitur here. And given the time, I won't address that further now. But the judge's third point, going over the page in paragraphs 211 to 215, is essentially a continuation of the second. In other words, the non-linear point. And he starts, as you see in 211, by saying that the respondent's construction with an annual adjustment reflects the wording, whereas the Republic's doesn't. And his view there, again, seems to be based on his conclusion on the wording and what I referred to yesterday as the left-hand side, right-hand side point. But again, without, with the greatest of respect to the judge, identifying an economic justification for the respondent's version. And similarly in 212 and 213, the respondent's argument is that an annual adjustment in the ratio of old to new year of base prices deals with the non-linear relationship because it ties the new base case to the 1993 measure. And we agree that that is the effect. I think it's common ground of the respondent's construction. And indeed, it is a feature of it. But it's not an economic justification for it, unless there is some inherent economic benefit in marginalizing the rebasing and tying the securities to the 1993 measure, which in our submission, there simply isn't. If one tries to stand back and think, well what? Just in broad terms, is the economic benefit of tying these securities to an outdated 1993 measure? There isn't any. And the arguments that the judge has gone through here, he's recited the arguments, but what we suggest needs to be done is to look behind them and to try to identify what the underlying economic justification is. In our submission, there isn't one. And when the judge, in his fourth point, at the bottom of page 140 in paragraph 216, he goes further there, because he there agrees with the respondents that it didn't make any sense, he says, to apply the adjustment fraction to 1 year only. And he says, in effect, that there's nothing in the adjustment provision to support that, and indeed no economic sense in doing so. But again, we would suggest his reasoning there is flawed. First, there is plenty in our submission in the wording to support our construction. And I've made our submissions on that yesterday. But secondly, and more importantly, the judge seems to have forgotten at this stage his own earlier findings as to sustainability, affordability, and the importance of tying the securities to the performance of the best measure of the real economy, which, as you've seen, were recited by him as recently as paragraph 209. Now, applying the adjustment fraction once provides the bridge between the 2 year of base prices, with the new rebased measure then standing on its own feet. And the judge's fifth point in paragraphs 217 and 218 was essentially to emphasize the significance on our construction of the overlap year. And we agree that it is significant to the level condition, as it recalibrates the level of base case by the 2012 fraction going forwards. But it's not significant, though, to growth, in the sense that it keeps the existing growth requirements, which it applies to the rebased figures. rather than having them tied with a wholly unpredictable and unknown result to the relative performance of the 1993 series. And picking this up, if I may, halfway through paragraph 217, the judge says it's difficult to see how our approach would be regarded as commercially sensible. But we would submit that it is a commercially sensible arrangement because it gives effect to the underlying purpose of the securities, which I've identified and indeed the judge identified. And the sense in the fraction turning on 1 year is that that fraction is the best and most accurate representation of where the economy is in those two different bases at the moment of change. And the point in 218 that it may be harder or easier to hit the required growth rate in the new measure is correct. But that's the whole point. Performance should be measured for better or for worse against the most accurate and up-to-date measure of GDP.
Then that would seem to point towards getting your fixed number by reference to 2004, not 2012, because the 2004 rebasing would be closer to the 2004 numbers than it would to 2012.
Well,
I know you've explained it by saying that this is the first year in which the different bases are available, but that base can be backcasted to 2004. And if you're looking for the most accurate measure of the economy in 2004 prices, why would you not arrive at your fixed number by reference to 2004 rather than 2012?
Well, my lord, in 2004, which is the first year of the 2004 year of base prices following backcasting,
Yes.
my lord's absolutely right. You have a figure. You also have a 1993 figure. And what you're doing there, if my lord is thinking of taking a fraction that then represents 2004 in the 2004 reference year and 1993 base in the 2004 reference year, my lord's right. You have a comparison of what the economy was 9 years earlier in those two different bases. But our submission is that if you're actually wanting to work out where those two bases are at the moment of change in 2013, and you need to go to the immediately preceding year, 2012, then the logic is that you take the fraction then. And of course, the respondent's logic is that you take the fraction.
I don't quite understand that. What your exercise is doing is producing a number which you then apply to all the figures in the base case table.
Yes.
And it's in a sense it's hypothetical, because you're using the figure to adjust, you're using your fixed figure to adjust all the numbers in the table. Now, it may not have any effect in years that have already passed, but you're looking to the future in multiplying by this percentage, whatever it is. So if you're going to choose the most accurate measure, I don't see why you don't choose 2004. I simply don't understand.
Well, my lord, it's perhaps it's a very short point. 2004 was 8-9 years earlier.
Yes.
What has since happened is that the economy has moved on in the sense that the scope in respect of 2004 and the scope in respect of 1993, of course, remains the same. Scope, methodology, and those points remain the same. But the measurement that you're taking in respect of those in the most recent year gives you the best indication as to what the difference is between those two measures at that particular time. Looking back 8 or 9 years tells you something about their relationship 8 or 9 years ago. It doesn't tell you anything about their current relationship. And indeed, the respondent's approach is that you have to do it each year going forward, because that tells you the best that you can know about the current relationship going forward. So, my lord, those are our submissions. in relation to why it should be 2012 and the economic justification for it. But the sixth point, if I can move on quite quickly to it, that is at paragraphs 219 to 223 of the judgment, was the respondent's so-called moral hazard argument, which proceeded on the basis that it was in the Republic's gift to decide when to rebase, and therefore what the overlap year would be. And the judge agreed with the respondents, as you see at the end of paragraph 220, that there would be no reason why investors would want to give the Republic that power, even if, as was accepted, it would be limited by the Braganza duty. Mademoiselle, my lady, there are two answers we would suggest to this. The first is the respondent's own evidence from Dr. Beuter, their expert, which you see recorded in paragraph 221. And as you'll see, picking this up in the third line, Mr. Valentin relied upon Dr. Beuter having accepted that any sovereign country which is going out to the market and wishes to signal it's a healthy economy will be incentivized to accurately report GDP rather than understate it. And Mr. Valentin also highlighted the fact that Dr. Beuter additionally agreed that the ability to wait 1 or 2 years to implement a rebasing would not be a powerful tool to manipulate statistics, as it would not be known in advance whether a future year would be more or less favourable. And in fact, the opportunity to pick a particularly favourable changeover year may not present itself at all. Now, that is quite important evidence coming from Dr. Beuter. That's the first point. But the second point is a more general one. If it's perceived that there are moral hazard risks in relation to that, they effectively pale into insignificance compared to the risks on the respondent's construction, where, as you have seen, the Republic is required to keep up an obsolete measure of GDP solely for the purposes of the security, not for general publication, not for monitoring by the IMF or other international bodies, and not for any economic purpose other than determining whether any sum is payable under the securities. And that was reflected in the judge's order, which I should, for these purposes, I think just show you briefly. It's in Core Bundle 1, tab 5, page 89. Where you see in paragraph 1B and C on page 89, the judge's direction that the Republic is required to produce the necessary statistical information and carry out those of the calculations which it is required to perform via INDEC, or shall procure such bodies to do so, and the Republic shall carry out those functions or procure that they be carried out in a manner which is consistent with the terms and conditions of the securities for proper purposes and in a way that is not irrational, arbitrary or capricious. And it is a short point, but if the Braganza duty is considered to be good enough or a good enough answer on the respondent's construction, then in our submission it must be on ours. And the last point in this sequence, seventh and last point in this, is the point considered by the judge in paragraph 224 of his judgment, the so-called proportional link. And this is something of a muddle, but as it ultimately doesn't advance matters either way, I will take it, if I can, as quickly as possible. The first point is it is important to distinguish between two types of proportional link. The first is the link before and after rebasing between actual nominal GDP and the payment amount. And you remember when we were looking at the excess GDP definition yesterday, that the amount there is based on the amount by which the actual nominal GDP exceeds nominal base case GDP. In other words, whatever the actual nominal is, if it exceeds nominal base case, it will proportionally increase the payment amount by the amount of any increase in it. And that is a truism, and it arises out of the definition before and after a rebasing on either party's construction. Now, it's just important to mention that because there is some confusion sometimes when there's a reference to proportional link, but that one is accepted. Secondly, though, there is a link, a different link, which arises on the respondent's construction after a rebasing between the payment amount in the old year of base prices and the payment amount in the new year of base prices. And that was explained by Dr. Boiter in paragraph 101.2 of his report. I showed you this yesterday, but perhaps for these purposes, I would ask you please to turn it up again. It's in Supplemental Bundle 3, tab 46, at page 84. And I referred you to basically the first 6 or 7 lines of paragraph 101.2, which talks in terms about the ratio, which is then, as I sought to show you, identified in the fraction at page, or the calculations, at page 100, and in particular 1.25, where you see that fraction in brackets in the last element of the calculation, representing YN 2013 over YO 2013. Now, it's agreed that this link mathematically arises on the respondent's construction, but it only arises after a rebasing. And it only arises because the respondent's construction, on the respondent's construction, the touchstone for economic outperformance remains tied to the 1993 year of base prices. So there's bound to be a proportional relationship between the old and new excess GDP. But that is a consequence of the respondent's approach. There is in our submission no underlying economic reason for the link. And the matter can probably most closely be seen from the respondent's cross-examination of Dr. Borenstein at trial. In view of the time, I wasn't proposing to take you to this now, but could I give you the reference, which is Supplemental Bundle 4, tab 64, pages 151 to 153. And it's his cross-examination on day 11, to internal pages 27 to 33, where he identifies quite clearly, and it's accepted by the respondents, that this link only arises on a rebasing. And Dr. Borenstein accepts that there is a link, but asks the question, well, what's the economic reason? What's the economic justification for this meaning that there's some particular purpose? You can be told that there's a link, and it is there mathematically, but so what? How does it affect matters? And an answer to that has been suggested by the respondents is that the link somehow shows that their construction deals with the fundamental requirements of sustainability and affordability, because it links, they say, any payment to the amount of cash that the Republic has to hand. But that itself, in our submission, is wrong. On their approach, the determinator for outperformance is and always will be 1993 GDP. In other words, it's the amount by which actual real GDP exceeds base case GDP, in each case multiplied by the deflator, and in 1993 terms. The respondents will always have that as a function of 1993 year of base prices. And all that the respondents link tells you is that the Republic is paying something proportionately different to what it would pay without a rebasing. But it's not telling you anything as to whether its rebased economy is doing better or worse than the 1993 measure. The rebased economy is its best measure, or the best current measure, of the Republic's real or true economy then. The link is not telling you anything about that economy. It's not telling you anything about the Republic's ability to pay by reference to that economy, that best measure of the real and true economy, which is, of course, the source of the Republic's tax revenue. And the reason why it doesn't tell you anything about it is because the respondent's construction doesn't fix the problem that it doesn't determine economic outperformance by reference to the most up-to-date and relevant measure of the economy.
I think we understand that point, Mr. Elton.
I'm grateful. Could I then go back to paragraph 224? And it's something of a jumble of issues and evidence within this paragraph, and one can slightly understand on the last point at paragraph 224 why the judge might have taken this quite quickly. But the common ground that's referred to in the second sentence relates to what I'd identify as the truism point I referred to earlier. In other words, it's in any reference year, the payment amount will increase proportionately to the actual nominal GDP. But that proportionality applies throughout on both constructions. And the respondent's other proportional
Well,
link.
you say that, but the next sentence suggests something different. That the experts agreed that that relationship is maintained under the respondent's construction, but not under yours.
Well, my lord, if what that is referring to, as we think it is there, is what I've called the other proportional link, then that is right. The respondent's other proportional link arises out of their construction. It doesn't arise out of our construction. But the truism,
So
the
what
more...
are you saying? Are you saying the judge misunderstood the evidence?
My lord, I'm not necessarily saying that, but what I am saying is that in his presentation or his reasoning here, what he appears to have done is to merge the two different matters, because there wasn't common ground, and indeed the evidence of Dr. Borenstein that I've just referred to but didn't show you shows absolutely clearly that the second proportional link only arises on a rebasing, and that was accepted in the cross-examination of him. So it may just be an error in the way that the evidence or the way that the judge is expressing his conclusions. But as to the fourth and fifth sentences, picking it up about a third or nearly halfway down, it is right that the payment amount is expressed in current or nominal terms. In a sense, that's obvious. But it's wrong there, we say, to say that there's no link to real GDP. That is the key ingredient to measure outperformance. And the example that's given there of level and growth going up in a reference year, but the payment going down or the payment amount going down on our construction using the rebased measure is only if you're comparing it to the position that would apply if the respondent's construction was right using the 1993 year of base prices. It is again the non-linear point, but appearing in a different guise.
Sorry, are you saying effectively it's only right if you use the respondent's approach as the starting point for your comparison?
Well, the two, where the judge, what he's picking up in the fourth and fifth sentences, where he refers to Ms. Previsa's submissions that our construction, the one-off overlap construction, can create a scenario in which even though both the level and growth rate of actual real GDP and the level of actual nominal GDP all go up in a particular reference year, the payment amount goes down or vice versa. And that is because of the points that I was endeavouring to go through yesterday, that because the two bases are non-linear, that is right, but only if you're comparing them to each other. You can look at the position in 1993 and you will find 1993 base, and you could find that base case increases growth. There's growth and there's the level. You could look at the same period in 2004 and you could find that there's no growth at all. And so if you're comparing the two, it is right to say that in 1993, you could satisfy the conditions and you could have a payment, but in 2004, you couldn't. And the last point, I think in the sixth sentence, in fact, I don't think I need refer to that again here. It's simply, again, the same point that appears to be misunderstanding the link. If the judge is referring to anything other than the truism, it doesn't exist prior to a rebasing. Now that was all I was going to say about the judge's analysis of the economic arguments. But before pulling together various parts on construction, could I address briefly our factual matrix argument, which is ground 2 in our notice of appeal. And there's no dispute here about the principle as to what amounts to admissible factual matrix. And the judge summarized that succinctly and accurately in paragraph 153 of his judgment by reference to Lord Hoffman's statement in Investors' Compensation. And there's no suggestion that that was wrong. And as you've seen, the judge concluded in paragraphs 154 and 155 that 3 matters were relevant in an admissible matrix. The first being the GDP-related concepts. Those include the points from paragraph 60 to 82, and in particular the points that I've shown you, I think now more than once, in paragraph 76 to 78, about the need to rebase and how the rebased measure is the best estimate of the real, true, or actual economy. Then in paragraph 154, the fundamental purpose, and in paragraph 155, the intention, made out and supported, as he said, by various presentations referred to in paragraphs 155 to 157, including at the end of paragraph 155, the quote that it needs to be based on Argentina's payment capacity over medium and long term. Similarly, at the end of paragraph 156, the reference to the repayment capacity of the debtor, and in 157, the quote referring to the long-term recovery. Now,
can I ask you this? There's quite a lot of evidence about the roadshows and so on to institutional investors, the IMF, so on. But what I understood correctly from Dr. Nielsen's evidence, that there was quite a high proportion of individual retail creditors, I call them investors, but they're really just creditors, to whom none of this material was presented?
Well, they particularly, I think, Italian. There was some Italian retail input.
Well, he refers to, I think, in Italy and Japan specifically, selling to retail investors. But some of the pie charts, not just in Dr. Nielsen's evidence, but I think in another document, put the estimates of retail investors, I think in one case at 43.5% and in another case at 35%. So really quite a significant proportion.
Yes.
Can one really rely on this, even if one's only looking at it in terms of the initial creditors, the initial holders of the securities? Can we really look at this as factual metric?
Well, as my lord knows, this is part of a restructuring of debt, and all bondholders of previous debt needed to make a decision as to whether to exchange their existing debt for new debt. And the purpose of various presentations and roadshows to creditor bodies throughout the world, and I think there's reference to there being something like 63 roadshows in various different countries, was to communicate to all those bodies. Now, I cannot say, and I don't think the evidence says, that every single individual creditor had a representative of some sort, however direct or indirect, at any of those.
Well,
But
you
you're-
need to go a bit, sorry to interrupt, you need to go a bit further, don't you, and say that the material that the judge identified as giving rise to relevant factual metrics was available to those retail investors, and he's not identifying whatever the number you chose of roadshows, just identifying a few examples of what is obviously aimed at major institutional creditors.
Well, my lord, I would suggest that there are two answers to that. The first is, if you are talking specifically about retail investors who have to make a decision as to whether to sign up to the restructuring, which required quite a significant haircut to be taken to enable it to be readjusted to what was affordable to the Republic, then it can be assumed that appropriate professional advice would be taken. But secondly, the Republic's material, or at least the vast majority of it, which I'm going to show you, was published on its website and therefore available to everyone, even if not in fact, even if individual creditors weren't at individual roadshows and not represented there. So, my lord, that's how we would address that. Now, the way in which the judge dealt with this, you'll see in paragraph 158, where he says he's unpersuaded that the material that he was shown shows that the parties proceeded on an assumption of long-term 3% growth in real GDP without regard to any particular base year. Now, it may not actually matter in practical terms, but we don't in fact need, I think, a common assumption for the purposes of matrix if the other requirements are met. What we need is information that's reasonably available to the parties, which would have affected the way in which the language would be understood by a reasonable person. And at its heart, of course, the issue here goes to whether the growth rates used in the securities embedded in that table are to be understood as growth rates relevant only to the then current measure of actual real GDP, in other words, 1993, or whether they are relevant to actual real GDP, however measured from time to time over the life of the securities, in other words, any rebased measure. And we say it is quite clear, in fact, it's quite clear when one stands back and thinks about the securities themselves just in their own terms, but insofar as it may not be, or you may consider it may not be, it is quite clear when one looks at the materials passing between the Republic and investors that everyone understood that the growth trends to 2034 being advanced by the Republic weren't tied to 1993 euro-based prices. Indeed, it would be illogical and uncommercial if they were, in circumstances where it was known, as the judge accepted, that there would be a rebasing at least once during the life of the securities. And any questions of sustainability and affordability would objectively have to be judged by reference to the best measure of the economy during that period.
Was this an element of factual matrix which the judge found to exist?
Well, the judge found
You've shown us the three findings he made, and I think this isn't one of them. I mean, are you asking us to make findings of fact that the judge didn't make about factual matrix reasonably available to the parties?
Well, my lord, the finding that I am asking you to make is in respect of the one that the judge rejected in 158 and in 164. Although, as I have sought to say, although at trial we pitched it that an assumption was necessary, we don't think we need to go quite that far to satisfy the investor's compensation test.
Does
But
that involve asking us to make new findings of fact?
It invites you to find that this should be he should have considered this as part of the factual matrix.
Well, apart from Mr. Katz's explanation of the internal workings of the ministry, what is the material on which you rely to overturn the judge's findings at 158 and 164?
Well, my lord, it's the material in supplemental bundles 1 and 2, in which I hope that my lords and my lady received an abridged reading list of particular items of documentation that we rely on. It's that material that was before the judge on which the submissions that identified this point were based.
I don't recall that being that list including a reference to a prospectus.
I think that's right.
So you're asking us to make findings about things in roadshow documents or presentations, not in the prospectus that would have been communicated to all.
Yes, that's right. And although there is the prospectus, there is an extract from the prospectus.
But we don't have, I mean, going straight to the point, for example, the percentages on which you rely, the long-term 3%, is that in the prospectus?
What in the 2005 prospectus, no, other than the fact that they are embedded in the base case table. As the judge found in the 2010 prospectus, they were there, but that document is not before the court.
Where's that finding by the judge?
It's paragraph 166, where the judge says, I might add that although the 2010 prospectus has a table which contains a column headed and then base case growth rate percentage with references to the relevant percentages. And you remember I showed you a table, an equivalent table, or one that identified the percentages that's attached to the defence. The judge then continues by saying it's clear nonetheless from the previous column that those growth rates are in 1993 year of base prices. And then he says, well, the 2010 prospectus can't assist as factual matrix, albeit I would question whether he's right on that, but for present purposes.
Difficult to challenge that here when we haven't got the 2010 prospectus.
Indeed, we haven't put, neither party has put that before you.
The judge makes a finding at 165, nothing in the 2005 prospectus, which which refers to a fixed percentage. We haven't got the prospectus, but that's his finding. He says there's not, it doesn't. I mean, if you're looking for the understanding of people who sign up to these securities, isn't the first place you go prospectus? Rather than trawling back through roadshows given all over the world?
My lord, in one sense, is right in that it is obvious that if the prospectus set out in detail the points that have now, many years after these securities were issued, become important, then one can see that. But there are certain points which at the time were simply understood commercially. And indeed, some of the judge's findings, when he talks about, I think in paragraph 23 of the judgment at the start, about how the long-term growth trend is being explained. A long-term growth trend is not a trend that can be linked to any particular year of base prices. It's meaningless to be attempting to do that. My lord, in relation to what we have in relation to the prospectus is an extract which is at, sorry, it's in our unagreed, the respondents unagreed bundle at tab 18. And this is, as I say, the only one there. The base case GDP is not identified. The base case GDP growth percentages aren't identified. And what you see underneath the table is the base case GDP will be adjusted in accordance with any changes to the year of base prices. And it's currently 1993. And then there is an example given underneath. Again, saying that it's currently calculated by INDEC using the year 1993. And then it says if in any year the year of base prices for calculating actual real GDP is changed by INDEC, the base case GDP will be adjusted accordingly. For example, if actual real GDP for 2006 with 1993 prices is X and with 2000 prices is Y, then the base case GDP equals base case GDP as per chart above multiplied by a fraction, the numerator of which is Y and the denominator of which is X. Now that envisages one change, the change going to the base case GDP as per the chart. It also envisages it being at one time, but what it doesn't do, importantly for these purposes, is identify if 2006 is the overlap year. But of course we would say it must be, because there won't be data for any other year when one looks at the wording of the securities.
Why do you say that envisages a change only at one time?
Well, simply because, back to a discussion we had yesterday, my lord, it starts by saying if in any year, and of course this has to be read with the wording of the adjustment provisions. And it's positing, it's looking at 2006, where there are then two different base years. So it's positing that you have had the 1993 prices produced for 2006 and the new prices. So it's an overlap in that sense. But the other extract we have from the prospectus is in supplemental bundle 2, tab 25. page 59,
Although this is in a respondent's unagreed bundle, I assume you don't mind us taking this into account. You say you've been lying.
well, my lords, my lady have asked about the prospectus, so it's quite right to show you, I think, the material relating to it that is before the court. And this is the other extract. It's from, I think, the same prospectus, the supplemental, or the prospectus supplement. And it's really the main, you'll see on page 59 under the heading Risks Relating to GDP-Linked Securities. And there is a main paragraph beginning, there are no principal payments. And it, 5 lines down, makes the point that Argentina's actual real gross domestic product for that year must exceed a specified amount in annual growth. And then says historical performance of Argentina's GDP may not be indicative of future performance. You cannot be certain that these conditions for payment will be met every year or at all. In addition, total payments over the life of the securities may not exceed the payment cap. And the securities will be deemed to have expired in any year in which the payment cap is reached. Furthermore, any alteration in the calculation or compilation of Argentina's gross domestic product by INDEC, the institution responsible for compiling Argentina's economic statistics, which is controlled by the Argentine government, may result in a decrease in value of or return on the GB-linked securities. And then it makes the point Argentina will not be required to make an adjustment to the amounts previously paid to holders of the securities for changes that may affect the calculation of Argentina's gross domestic product. And so what that is doing is it flags, as we suggest is quite clear from the wording of the adjustment provision anyway, that if there is a change in the measurement of gross domestic product, that may result in a decrease in value of or return on the securities. And that indeed does happen.
Presumably you would accept that the last sentence appears to be backward looking, and so looking at the last sentence there is backward looking, so backcasting, because it's talking about adjusting amounts previously paid, which naturally refers to, backcasting has produced what look like different results to then.
Possibly. My lady may be right in respect of that, but as the court may well know, there are adjustments that are made, and indeed if one thinks of UK GDP being announced every now and then and being adjusted in subsequent periods, there are running adjustments that are made without necessarily any change.
Yeah, so that's the sort of revisions, I think the term revision was used in something we saw yesterday.
I think that's right. But this point possibly was directed first to revisions, but my lady is right, it could certainly in principle cover the wider point as well. That's the prospectus. Another of possibly the more public-facing documents, which I should possibly show you at this time as well, is in Supplemental Bundle 1, tab 13.
Just to remind you, Mr. Relton, it's 11:30 when you told us you would be finished by 12.
I know, my lord, I'm not doing well, I'm afraid. I have mentioned this to Ms. Provisa. I'm hoping to sit down before lunch, but I'm not too sure how long going through this material will take, or if indeed if my lord is going to permit me to go through it.
Right, well, we're going to tab 13.
Tab 13 is the SEC form.
I'm sorry, which bundle were we in?
Supplemental Bundle 1. And this is the form 18KA. And one sees, in relation to this, at page 224, the final proposed terms And in one sense, we would suggest this is in a similar category, you may think, as the prospectus. It summarises the reference amount at the top, which picks up a point my Lord mentioned yesterday. It's in respect of the principal amount of bonds tendered for exchange or amendment. But 4 bullets from the bottom, the payment trigger, actual GDP expressed in constant paces, as of the reference date, exceeds the base case GDP and the annual growth rate exceeds 3%. And base case GDP, projected real GDP from December the 31st, 2004, at an annual growth rate of 3%. No suggestion at all in that it is linked to the current year of base prices of 1993 for all time, or indeed at all.
That's inaccurate even on your case, in relation to all the years prior to 2015.
3% has been rounded for those purposes, yes. We accept that.
It's an SEC document.
Yes, but one, there was then a debt exchange offer and a swap offer, which again were public and on the website, which I'll show you in a moment. And perhaps if I could now just show you some of these documents. If my lord or my lady considers that it is unhelpful to go to them, then I will cease the exercise. But perhaps I could start by going through some to give you the flavour, really, of what the points are. Although it might actually be best first just to show you the expert joint statement on this, which is at Supplemental Bundle 3, tab 47. Page 110. And this is paragraph 10 of the joint statement, where the experts agree that base case GDP is based on estimates of 1, the long-run growth rate of potential output, the long-run trend, and 2, the initial cyclical position of the Argentine economy, the initial condition. And base case GDP, they agreed, was denominated in 1993 pesos because actual real GDP was estimated using the 1993 GDP year of base prices at the time the GDP-linked security was issued in 2000.
It's my fault, I haven't found where you are.
I'm so sorry, my lord. It's Supplemental Bundle 3, tab 47, page 110. And paragraph 10 of the joint expert statement. Now, as for the materials that we rely on, if I could pick it up first in Supplemental Bundle 1, tab 1, which is the speech of Dr. Lewison when debt restructuring proposals were first launched in Dubai to creditors, September 2003, a document published on Mekon's website. You'll see from the first paragraph that a number of representatives have travelled from different countries. On page 9, at the bottom, Dr. Lewison is saying, first of all, we'll summarise the medium-term sustainable macroeconomic framework, then explain the restructuring principles. Page 19, if I could go forward to that, restructuring principles, and there's a section where the key restructuring principles and objectives. The third is achieving a sustainable solution to the debt problem. And on page 28, the basic features of a proposal, bullet point 1, needs to be based upon Argentina's payment capacity over medium and long term.
How does this add to what the judge found?
Well, my lord, because what it is doing, And it may be that if you're with us on what the judge was actually referring to by saying that a reference to medium and long-term capabilities and growth is not tied to 1993, then my lord, it's absolutely right. This doesn't add to it. This material is designed to show you that it is quite clear at the time that medium and long-term growth is not identified by reference to 1993 only. It's identified by reference to real GDP. And one sees this in this document, I think, on page 32. Just payment capacity. The macroeconomic working assumption, first line, real GDP growth, long-term 3%. You will see in the paragraph underneath, Dr. Nielsen is saying we need to assume an annual growth level to project repayment capacity. And at the next tab, there's a presentation to the consultative working group meeting, also published on Mecon's website. And picking this up at page 44, one sees the restructuring objective. And my lord may fairly say, well, the judge has agreed with this. You'll see the first and third bullet points. The objective is to attain a sustainable and credible path of growth. Going forward to page 72, again the point in the first bullet relating to allow growth to maximise payment capacity over the medium and long term. Through to page 98, the growth, a formula is set out that the premium equals the difference between the growth rate of GDP and a threshold rate, G star. But again, it is by reference to GDP, to real GDP. It's not tied to 1993. On page 100, one sees in the last bullet, this is under the heading, will pricing be difficult? Growth is easier to predict than interest rates. It's closely watched and many publications provide predictions and analysis. There are 50 years of reliable data on GDP growth. Tab 4 is a reaction by a group of bondholders to the Dubai proposal in December 2003. I'll just show you page 123.
Is this on the website as well?
That I don't know. I will just take instructions while showing you page 123. The third line, under the heading Key Medium Long-Term Assumptions, GDP growth target 2004 to 2030, Dubai guidelines 3%, ABC guidelines 3%. But these are not tied to any particular basis. But I'm told this particular document wasn't on the Mecon website. The next one at tab 5 was, this is the 4th of December, a presentation by Dr. Nielsen. And perhaps I need only show you page 133. In the middle of the paragraph, in the middle of the page, there's a paragraph that begins, let me briefly reflect on the guidelines presented in Dubai. And you'll see that he refers to various variables and says, of these variables, the most important one is growth. Any debt restructuring can only be considered successful if the restructured liabilities can be matched by the repayment capacity of the debtor. And over the page, he refers in the second paragraph to debt restructuring guidelines being discussed in a consistent framework based on realistic assumptions And then investors should have the opportunity to share in any repayment capacity enhancements that would follow stronger than envisaged growth. It's an invitation effectively to investors to share in that upside. And one sees at the end the reference to servicing of our obligations in a way that ensures a sustainable path that gives our creditors the opportunity to benefit from Argentina's growth. And that just must obviously, as we say, the securities on their face, is obviously looking at the actual growth, not some nominal growth in some outdated series. On tab 8, if I could jump forward to that, another presentation by Dr. Nielsen, which was published on the website, it's referred to in the judgment. Pick this up at the bottom of page 147. It does refer again to a sustainable debt restructuring and a final resolution to the debt crisis. And at paragraph, page 150, 2/3 of the way down, we're firmly committed to negotiate in good faith by defining variable payments and bond enhancements according to the actual improved performance of the Argentine economy. Both Argentines and international investors will have the opportunity to share in the improved performance of the economy. And at the top of the next page, you see that there's a reference to the potential upside benefits that a long-term recovery of the Argentine economy offers. Again, it's not 1993 base, it's the actual economy. At tab 11, there is one of a number of analyst reports. This one is from Morgan Stanley in April 2004. And just to show you on 2005.
I'm sorry to keep asking, is this on the website?
No, this isn't.
How is this relevant to interpretation? What the broker thinks?
Well, it is an analyst document.
All right, so it's an analyst document.
Analyst documents, we would suggest people who would be purchasing these securities would be looking at analyst documents. But even if that were wrong, the point that is made about how people actually look at it, it is, we would suggest, a fairly obvious point that one of the key elements when considering what these particular securities are and what they are worth, and to try to make a projection or an understanding of what their value is, you need inputs. And is the input going to be in relation to real growth, the actual economy? And is that going to be measured by looking backwards as well as looking forwards, or is it in a particular year of base prices? But my lord, I will take this very briefly. On page 205, one sees that the macroeconomic scenarios and valuations, there's a table on the right-hand side. The first entry is real GDP growth. And on page 208, one sees in the bottom left-hand corner that what these analysts are doing are looking at growth statistics over 100 years and explaining where they've got them from. And their assumption is a mean growth rate of 3%. Lord, if I could move on from that to tab 12.
I think that one wasn't amongst your reading list, was it?
My lord, I'm sorry if it wasn't. That may have been a better decision having been made by others behind me as to what to trouble my lords with. Tab 12 is a press release by the Republic, referred to in the judgment at paragraph 160. It refers on page 218 back to the Dubai guidelines or proposal, and quotes how the sustainability of the offer is essential. On page 219, in paragraphs 2 and 3, It's referring to the number of meetings with various creditors and how a great deal of work, this is paragraph 3, has been carried out to update and refine the long-term sustainability model, which will be available to all interested parties on the website of Mecon. And page 220, paragraph 6, refers to a growth-linked component, GDP unit, is added to the aforementioned bonds, which will increase the payments derived from the bond menu presented each year if growth actually achieved by the country during the previous year exceeds that projected in the sustainability model. In this case, Argentina will share part of the surplus with the creditors. The surplus that triggers the payment of this component is defined in the medium term as that which exceeds 3% annual growth. These are not payments on estimates or prospects, but on growth actually achieved in future years, starting from the year 2005. Again, clearly we say it's a reference, an intention behind it is to actual, real or true economy and the best measure of it, not tied to 1993. You've already seen at tab 13, the SEC Form 18KA. There are then a series of analyst reports, which I won't show you two, but I will go forward if I can to bundle 2 to the debt exchange offer. Which was on the website at the time and
Which
still
tab?
is, I understand.
Which tab?
I'm sorry, my lord, it's tab 24. I referred to in the judgment at paragraph 161.
Sorry to be picky. Does your still is mean that the others came down from the website at some stage?
I think that's right, but they are available. I don't know when they came down, but they are available, as always, on a way back search so that you could find whatever is there. But I can't say that they are still there on the front of the Mecon website now.
So I'm using a way back search.
Well,
If someone buying a security today looked on the website, they wouldn't find it.
well, you would if you did a search to find what was on the website during 2005, 2006, or whatever the relevant period would be. You would do that. But I understand that this document, and indeed it may be one or two others as well, and I will identify those, just remain there so that you don't have to do any particular detailed search to do it. You do, of course, have to search through whatever the menu is.
This does raise the question of whether something is reasonably available if you can only find it on the internet by doing searches.
Indeed, my lord, but if you've got, and of course at this stage you're talking about purchasers in a secondary market who will be sophisticated purchasers, as indeed the claimants, respondents here are, as to the assumptions as to what material that they would dig into and look at. Those would necessarily, we would suggest, include analyst reports, as that's how purchases would be done. But could I continue with going through this? Yes, I'm told tab 26 is also currently on the website. But on tab 24...
So tab 26 of this bundle.
Yes. Tab 24, I think, just to show you the view of the time, page 39. This is outlining what the offer is, and you see halfway down page 39, the entrance for base case GDP, then a figure is given for 2005, and a growth of approximately, and then the various percentages that you've seen are set out, and 3% thereafter. No hint that the 3%, or indeed any of these figures, are tied to 1993. And indeed, excess GDP is talking about the amount, if any, that actual real GDP exceeds the base case GDP. That's the debt offer. The swap offer is at tab 26. And I would,
Sorry, you said this is the exchange offer. The title is Roadshow Presentation on that subject. So I'm just trying to understand the status of this document. It's like a presentation.
my lord, sorry, my lady.
I believe it's a presentation, this document, rather than some form of contractual document. It says it's the exchange offer, but it's a presentation related to it.
Well, going back to page 20, it is identified, of course, as a debt exchange offer, and page 21 is saying that it's not an offer or solicitation of offers, but it is referring to it as the exchange offer. I mean, it may be terminology, in that, in a sense, it obviously is a presentation in relation to the offer. Are you on tab 26, my lady, or tab 24?
I'm on tab 24, because I thought that's what you were taking.
Yes, indeed, indeed.
There's a disclaimer at the front of the document.
Could I move on though? Sorry, page. Yes, my lady's right. The disclaimer on page 54, indeed. But on tab 26, there's the swap offer, which, as it says on page 62, doesn't constitute an offer to sell. That's the name of the document. And just to go forward to page 70. Again, the table that is set out there, terms of payment. For the reference here, observed real GDP exceeds the GDP base case. And then there's the footnote, projected growth path for the Republic of Argentina. And observed real growth exceeds GDP base case growth rate, does not exceed the established ceiling. And there is no suggestion in reference to in the references to real GDP that you are talking about anything other than real GDP, which is GDP in the most relevant and the most recent measure. The other documents I was going to show you were analyst reports, which, in light of my lord's lack of enthusiasm for them, I won't go to now, and it may well be that you might have looked at some of them in any event if they were in the reading list. But what we do suggest is what this material does show, clearly shows, particularly if you put it together with the judge's unchallenged findings, that the road shows involved the Republic explaining the predetermined growth trend line. And you put it together also with the evidence you've seen about potential GDP and what potential GDP actually is. What this suggests, we say quite strongly, is that the figures were never presented as, or indeed wouldn't reasonably be understood as being, growth rates specific to the 1993 base. They're growth rates for the real, actual, or true economy, not assuming that any part of the future economy of Argentina is to be ignored because it's outside the scope of the 1993 base. But it's rather assuming that the best current measure of the economy from time to time is to be used. And indeed, once it is understood what this exercise is, in other words, the devising of a mechanism whereby both the Republic and investors share in the future growth of the economy, we suggest that it is obvious that commercially all parties would want that to be by reference to the best measure of that economy. And it is noticeable that in all the material that we have been through, and indeed that we've referred to in our skeleton. There is absolutely nothing in our submission that supports the respondents' construction. The best it gets for them is an identification of the level of actual real GDP in the current 1993 series. But that is because, as you've seen, and only because, at that moment, the moment when the securities were issued, and until it is changed, the 1993 measure is the Republic's current measure of actual real GDP. But the critical ingredient is actual real GDP, not the current measure. Now, there's absolutely no hint either, going back to a point discussed yesterday in any of this material, that after a rebasing, the Republic would break with standard international practice and will continue to assemble and publish information on the 1993 base. On the respondents' construction, that would be a critical commercial consideration, but there's no hint of it anywhere. Now, the judge rejected our submissions on this in paragraphs 165 to 170. But, my lords and my lady, unless it would particularly help you to go through that, I think you have my submissions, which are quite easily translated into why we think the judge went wrong in relation to that. And it may not need more oral elucidation, but I'm very happy to run through those quickly if that would help.
Well, it's up to you, Mr. Relton, but you must finish by 1 o'clock.
Indeed. On that basis, if I might leave matters as they are in relation to it, I think based on the submissions that I've made, it would be quite clear why we think the judge's reasons don't work. But just one other point to add to that, there are 2 or 3 paragraphs here where he does refer to Mr. Katz's internal thinkings. I think on any view, that would be or should be accepted that that is not relevant, didn't cross the line, not shared, either with all investors or a body of them. Could I move on then to ground 3 in our notice of appeal, our alternative case on the Chartbrook principle? And I can, and in the circumstances, will take this, I think, very briefly, not least because the substantive ground, I think, has already been covered in the submissions I've made on the true construction. But it's largely as a consequence of the judge wrongly considering much of the economic and commercial construction arguments in the context of Chartbrook, which is why we've actually covered the ground already. Had he considered that in relation to the iterative process, then the judgment would have been framed differently. Now, we absolutely recognise that there is a significant difference between the process of interpretation, which, if properly addressed, will accommodate commercial and economic considerations and indeed linguistic infelicities. There's a difference between that and the correction at the end of that process of a mistake. And in practical terms, this alternative case of ours only arises if you conclude, as the judge appears to have done, that the language of the adjustment provision is so clear that it effectively closes down the court's ability to give effect as a matter of construction to the commercial and economic considerations which we've identified. So this alternative case has a narrow sphere of operation, and it is not one that we say we need, but we rely on it in the alternative in case you consider that the language drives you to the Republic's construction. Now, there is, again, I think, no dispute on the relevant underlying principles. The judge accurately summarised those in paragraphs 144 to 151 of his judgment. There are 2 relevant considerations. one relating to the mistake in the drafting and the other relating to how it's to be cured. Now, as for the mistake, I think it's clear, in particular from the quotes of Lord Justice Nugent in the Monsola case at paragraph 149 of the judgment, that what is needed here is a result which is in effect irrational, nonsensical, or absurd. And a number of different ways in that quotation from paragraph 32 of Monsola express the sense as to what the target is. And we accept that it is a high bar. Now, as for the cure, again, if there is a mistake, the nature of the correction must be clear. And one sees that, again, quite clearly from a paragraph 150 of the judgment, where the judge cited Lord Hodge in Arnold at 78. Now, that does not, of course, mean that the correction can be expressed in only one way, or with a limited or succinct adjustment to the drafting. As Lord Hoffman said in Chartbrook itself, there's no limit to the amount of red ink that the court is allowed. Now, against that legal background, I think, at least hope I can make our submissions very shortly with a minimum amount of repetition. But the starting point is that if the respondents are right in their construction, the securities following a rebasing are no longer linked to GDP. They're no longer linked to GDP as published by Index in the current measure, but they're linked for all time to an historic and out-of-date measure of the economy, which no one, we say, ever had any reason to believe would be produced going forward. Now, as a result, the critical targets of sustainability and affordability and any economic outperformance are to be judged by the old measure for all time, despite the fact that everyone knows that that old measure is and becomes increasingly disconnected from the real, true, or actual economy. And in our submission, it is irrational and a nonsense. It's irrational and a nonsense for the Republic's economy to be judged on an old measure and for investors' returns to be judged on an old measure, and for them to be excluded from any improvement in GDP, which the new measure brings. You remember I referred you yesterday to the book by Mr. Williamson and indeed to Dr. Borenstein's own evidence. Why would anyone want to invest in an economy that isn't there? The rational interest for both parties is clearly the best and most up-to-date measure of the economy. Now, as to the nature of the cure, if you accept that at least the first bar is crossed, as to the nature of the cure, the drafting problem which creates the issue is the application of multiple annual fractions, which give the effect that everything is tied to 1993 year of base prices. And that is addressed, if that is the problem that is to be fixed, that is addressed by making it clear that the same fraction is to apply to all years going forward. And you can see from paragraph 187 of the judgment, where the judge set out our suggested wording on this Chartbrook line. And the additional wording is underlined, and as you will see, it also includes here dealing with the question of subsequent rebasings. You see the first four underlined words, or as previously adjusted, and the last phrase at the end, or if index has affected more than one change, the previous year of base prices. Those go to the question of subsequent rebasing. We say that is implicit in any event and could be dealt with by an implied term only, but included here in case you consider that the implied term otherwise doesn't work. It is quite obvious, we say, that future rebasings are to be taken account of. But the key language for present purposes is the middle part, the underlined words, calculated for the last reference year for which official indexed data is available. Now that necessarily ties the fraction to the overlap year, which we say is the only relevant year for which the required information would be contemplated to be available, which, as I submitted yesterday, must be the source for the intended fraction. So it fixes the problem. And there may, we would accept, be other ways linguistically to do it. But if you accept that looking in 1993 year of base prices is a mistake, and the intention is to have a single fraction based on the overlap year, this we would submit is the nature of the correction to be made.
What do you say about the point the judge made at paragraph 217? In the last sentence, he says that if you're going to use a fixed factor, it would make more sense that the risk should be spread, in the sense that, as Ms. Pruiza described it, there is a weighted average of several overlap years.
Well, my lord, I've made submission in relation to that. There are a number of answers. First, I mean, one is the point we addressed this morning, that if you're actually wanting to see what the economy is as the best comparison between them, between the two different measures, 1993 and 2004, you want to know what the difference is between them in the relevant, the most recent, and we say the overlap year. That's what the two economies are doing at that moment of change.
But just standing back for a moment, the commercial and economic consequences of the rival constructions which you've been praying in aid, that which you suggest was intended, preservation of the growth in the old table and using for sustainability and availability purposes the up-to-date actual GDP, is equally be achieved if one chose, instead of the overlap year, either the first new YOBP year, 2013 in our case rather than 2012, or backcast to the year which is the new year of basis prices, which my lord mentioned, 2004. All of those would achieve the objectives you say were intended to be achieved.
My lord, that's right, because you'd have a fixed fraction, and one fraction, one fixed fraction means that all you're doing is recalibrating the base case, but keeping the growth, the embedded growth levels there.
But they would illustrate that therefore there are a number of different ways in which case laws might be reframed.
Well, save that.
If you're right at stage one that as framed it's nonsensical and irrational.
Well,
And they would be different mathematically, wouldn't they? The different ways of doing it. I mean, it's not like non-solar, where I think Lord Justice Nucci said, well, there are two ways you can express this formula, but it doesn't matter which, because they produce the same mathematical result.
my lord's right, because the adjustment fraction that appears from the document I showed you yesterday will change between 2004 and 2012.
But not only that, the level it'll affect the level condition as well, won't it?
That's right. Although, I mean, in practice, not in the sense that the level condition is satisfied on whatever. But you're
Well,
right.
it is for this year, but may not be indefinitely.
But one has to, my lord's quite right to look at the broad economic and commercial points that I've referred to. But the decision as to what the answer is, as to which year you go to, is not at this stage and in this context an abstract one. Those economic points could be resolved by taking a single fraction in one sense in any year. But the securities don't tell you that. The securities guide you in a number of different ways that need to be taken on board. Because in looking at what the error is and how you cure it, you don't ignore for these purposes what the securities actually say. For example, in relation to 2013, that we would suggest is ruled out because there won't be the 1993 information to enable the fraction to be calculated in the ordinary way, absent an implied term. The ones before 2012, we say are implicitly ruled out because what the securities are doing as a whole, by looking at the growth provisions, just in actual real GDP growth and base case GDP growth, they're looking at the immediate preceding year. And as my Lord Justice Popplewell referred to yesterday, when you're looking and comparing actual real GDP growth in actual real terms, there is a certain degree of sense in making sure that you're applying the same current measure to base case as well. And we say all those factors, which I was submitting yesterday, point you towards 2012 as being the overlap year, point you that the cure is to identify clearly, which is what we do in our proposed Chartbrook revision to 2020 to 2012 as being the relevant year. Now the other point, or another point that was relied on by the judge in paragraph 227, not just the point that my Lord Justice Lewison has referred to, but another of the reasons that the judge rejected this were because we ourselves are advancing a further alternative case on the Hubbard deflator, which the judge suggested showed that the cure wasn't clear. That, though, we would suggest is simply wrong. The Hubbard deflator is not advanced as a cure for the mistake, but proceeds on the basis that the respondents are correct in their construction. And perhaps I can turn to that particular point, ground 4 of our notice of appeal now. Now, this is based on the assumption that the respondent's construction is in principle right, and what is required is the application of a separate fraction each year. And of course, as my lords and my lady know, we fundamentally dispute that. But if it's right, a question arises as to what the ingredients of that fraction should be each year, and in particular, what the denominator should be. And if I could go back, please, to the proviso on page 36 of the terms. A point that my Lord Justice Lewison drew attention to yesterday. The fraction, when being identified in the mechanism element of the clause, identifies a numerator, which shall be actual real GDP for such reference year, measured in constant prices of the year-of-year base prices. In other words, actual real GDP. And the denominator of which shall be the actual real GDP for such reference year measured in constant 1993 prices. Now, so far, we have proceeded on the basis that the respondents are right, that this is a reference in the denominator to real GDP for the year in question, calculated on the basis of the 1993 base. And that's why they need the previously unheard of task of INDEC producing figures going forward on that basis, the 1993 basis. Now, Professor Hubbard, however, pointed out that this is not actually what the clause says. at least so far as an economist is concerned. And that because the denominator refers to the defined term actual real GDP, which you'll remember by reference to the definition on page 35, is measured in constant prices of the year of base prices, and following a rebasing, the year of base prices, of course, is 2004. And as Professor Hubbard points out, the denominator does not say that it's to be measured in the 1993 basis. It says only that 1993 prices are to be used. And indeed, in the judge's order, if I could just ask you to turn that up again, it's in Core Bundle 1, tab 5, at page 89. Paragraph 1A, where he is making his declaration in respect of the meaning of the securities. What the judge did, and indeed necessarily had to do, was add a gloss to the language of the clause by referring, as you'll see at the end of paragraph 1A, just opposite the first hole punch on page 89, by identifying that the denominator of which, he's referring here to the fraction, the denominator of which shall be the actual real GDP for that particular reference year, measured in 1993 year of base prices. And so from the point of view of the judge's approach, he's accepted what the respondents has said, but necessarily to translate that into his declaration, he needs to add or gloss the words of the clause. Now, this change is important because as...
But gloss the words, which words is he glossing?
I'm so sorry, my lord, it's on page 36.
Yes.
The denominator where you see
the securities say 1993 prices and the order says 1993 year of base prices. Is that the point you're making?
The security says actual real GDP, yes, which by definition will put you to 2004, for such reference year measured in constant 1993 prices. What he is saying is that the denominator is 1993 year of base prices actual real GDP. And it's important. It may seem like a small difference, but it's a very important.
The difference is that you adopt the 2004 scope of methodology on your case.
Absolutely.
And all you change is the pricing, rather than applying the 1993 methodology.
My lord has it exactly, because as Professor Hubbard points out, there is a distinction between base year in the sense of scope, methodology, and prices. And as he explained, a base year refers to the structure of the economy at that time, including not just scope, methodology, but weights and all of that. Well, constant prices, which is the full term referred to there, constant prices adjust for inflation between the two relevant years or over the relevant period. And looking at that adjustment provision, if in the language of the denominator, actual real GDP is to be given its defined meaning, it must be requiring the current year of base prices, i.e. 2004 base. Otherwise, one can see it would be saying something different. It would be saying something such as gross domestic product for Argentina, for such reference year measured in constant prices for the 1993 year of base prices, as or to be, following the judge's judgment, published by India. And requiring the 2004 base to be used in the denominator also makes sense, as that is the only measure, absent the judge's implied term, which is published by Index going forward. Now, if the denominator requires the 2004 base to be used, the reference to constant prices can only be to adjust the 2004 figures for inflation. In other words, the conversion which needs to be made to the base case figures following a rebasing turns not on the ratio between actual real GDP in two different measures for the same reference year, but it turns on the ratio between the 2004 measure in 2004 prices and the same measure, 2004 measure, deflated to 1993 prices to account for inflation. And as Professor Hubbard explains, that is easily done. INDEC publishes a deflator which represents the level of inflation between 1993 and 2004. It's set out in his report, his first report, at paragraph 115, which is a supplemental bundle 3, tab 52, page 266. But it is, and it may actually be helpful just to show you that now. And this is the section of his report where he deals with the deflator. But at page, so paragraph 200 and I'm sorry, it's tab 52. If I said 53, that's an error.
52.
52, page 266. And he starts addressing this actually on the previous page, paragraph 114, where he introduces the way to present GDP for 2013 and beyond, expressed in 1993 prices using existing data from the 2004 base or from any subsequent base. In the case of 2013, this presentation requires taking real 2013 GDP from the 2004 base series and adjusting it for inflation across total production in order to convert that figure to 1993 prices. This method preserves the updated weightings and methodological improvements of the new base case series, thus allowing for accurate data while still measuring economic output in 1993 prices. As he says, the best deflator to use in applying this inflation adjustment method is a GDP deflator using the official GDP figures published by INDEC. As I explain in my textbook and elsewhere, the ratio of nominal GDP to real GDP, otherwise known as the GDP deflator, can be used to measure inflation in an economy between any year and the current base year, which becomes year zero for the purpose of real GDP following a rebasing, and thus sets the new benchmark for inflation since the base year. This notion forms the basis of the rationale behind the following inflation adjustment method. Excuse me. To estimate the Republic's 2013 GDP in 1993 prices. And you see step one, as he starts from real GDP in 2013, in using 2004 as base year. Step two, he employs the deflator from 1993 to 2004, calculated as the ratio of the Republic's 2004 nominal GDP as measured in the 1993 GDP methodology to its 2004 real GDP from the 1993 base series and represents the level of inflation between 1993 and 2004. And you can see over the page the calculation that he makes that produces the factor of 1.6. And his step three is that you deflate the 2013 real GDP using 2004 as base year to 1993 prices by dividing it by the GDP deflator derived in step 2. That is what he does, and he produces his 542 billion figure. And as he says in paragraph 16, this method can be used to calculate the best estimate of the Republic's real GDP in 1993 prices for every year following the start of the 2004 base series. And one sees over the page in figure 8, that is the percentages, that fixed factor applied in respect of the rebased figures. And you'll see in paragraph 117 what he says, that this inflation adjustment method is the most economically appropriate method of ascertaining the best evidence of GDP in 1993 prices for reference year 2013 for the following reason. A, the most recent base year better captures the Republic's economic structure, indeed a point I've made more than once. B, the method prevents the inaccuracies caused by using a substantially outdated GDP series. C, the calculation can be performed with available data published by INDEC and can be performed on an ongoing basis, including after any subsequent rebasing. And D, the calculation doesn't require the Republic to use different data and methodology to calculate GDP using 1993 and 2004 as base years on an ongoing basis. And so what you get by applying this is a constant fraction that effectively turns, or constant fraction until there would be a subsequent rebasing, but it effectively turns 2004 scope, base and prices into 1993 constant prices by looking at the measure of inflation between 1993 and 2004. And it simply deflates the 2004 figure to 1993 prices. And in the language of the clause, again, going back to it, the denominator shall be actual real GDP, in other words, 2004 base, measured in constant 1993 prices. What Professor Hubbard does, he takes the 2004 base, he measures it in constant 1993 prices because he applies his deflator.
Can I just understand? So if we look at 115B, employing the index GDP deflator from 1993 to 2004, and then there's footnote 171. That's the published data you say is available.
Yes.
Have we got that anywhere? I expected it to be electronically. I could follow the link.
I'm not
Have we
sure.
got what's in footnote 171? That's a
would
one-off publication when there's a basis change. Is that in 2004? Was that is that extrapolated from some other inflation document?
I would have to come back to you in relation to that.
Because if I've understood correctly, this has nothing to do with the GDP deflator definition in the instrument.
No,
This is simply an inflation exercise,
Yes.
a deflation exercise.
Yeah. But what it does is it's effectively telling you what inflation is between 1993 and 2000.
I understand it conceptually.
Yes.
If someone could find me something to have a look at.
Yes. It may well be in an appendix that isn't reproduced before you, or it may just be that what the parties have been proceeding on is the basis of Professor Hubbard's description. But I will find out.
Well, he's got a hyperlink there, so I suspect if I've got this electronically, the hyperlink might work.
If I've understood it correctly, the deflator is just the ratio of GDP.
As in.
And using 1993 methodology, that's the diagram at the top of the page. the folio at the top of page 267. Anyway, let's move on. That's the method used to measure inflation.
Well, what it's doing is taking the figures on the difference in 2004, effectively, between nominal and real. So it's not the same as in the securities, or in
No,
one
I
sense it is.
understand.
Yes.
But it appears to take figures that you would normally expect to be available.
Oh, indeed, indeed. Yes, I mean, absolutely. But precisely how they are published, I will come back to my lord in relation to that.
Thank you.
But the output of it, we would say, is that it gives you a fraction that's based on the most recent measure of the economy, not the outdated one. It's adjusted for inflation back to 1993. And it is giving you, we would suggest, the best sense as to what the current measure would have looked like then. And it's really a very, we would suggest, simple and attractive solution for bridging the two series. It preserves the growth rates inherent in the table, and it avoids, importantly from my client's point of view, the expense, inconvenience and distraction of continuing to publish in the 1993 series.
And if I've understood correctly, you calculate this fraction year by year.
No, it's a one-off fraction.
No, it's still a one-off fraction.
Oh, I'm so sorry, I think we were at cross purposes. It is the same fraction, but on the respondents construction, you apply it every year.
So on the hypothesis we're looking at, it is an annual adjustment.
Yes, indeed, and I'm so sorry, my lord, I misunderstood your question.
That's why it's an annual adjustment by which you strip out inflation only in comparing the two figures.
Yes, you're turning the 2004
Yeah.
actual real GDP
Into 1993 prices.
into 1993
Yeah.
constant prices. Indeed.
And you do that in 2016, 2025, 2030 and so on.
Absolutely. We're in the world where the respondents have succeeded on their
Yeah.
construction.
And I thought you said a moment ago that would preserve the growth figures in the base chart.
Yes.
No, it doesn't. Yes, it does. Yes, it does.
I can hear no's and yeses
Yes.
from behind me, but I'm not quite sure what's there.
From behind you, there's lots of nodding,
Yeah.
and opposite, there's lots of shaking of heads. So
Yes.
we might have to drill down on that. I don't.
I'm also unclear how you would do that deflator calculation for periods after 2004.
In the sense of,
Because what you're saying you apply it every year. You have to apply it to all the new years, so you're not just deflating from 2004.
yeah, well, perhaps I can just explain that. I hope I can explain that. And let's take the example of 2016.
Yeah,
2004 actual real GDP is produced in the normal way, published by Index. On the respondents construction, what you then have to do is to identify what that looks like in constant 1993 prices. And so you have your 2004 measure.
it's a constant 2004 on the new
You're already in
rate.
2004
Right.
prices, so you don't need to go any later than that.
Yeah.
It's adjusting for the difference between 2004 and 1993.
Thank you.
Absolutely. And the judge considered this and rejected this alternative case in paragraphs 233 to 246 of his judgment. And I think essentially for three reasons, describing it, I think, slightly unfairly as a hopeless case. The first reason was a linguistic one, which he expressed in two ways. First, you see this in paragraph 239,
just before we go there, has the judge accurately summarised what this case is in his paragraph 235?
My Lord, the wording that's put forward there was, I mean, it's illustrative wording as to how this particular point is teased out. We're not suggesting that there should be any alteration to the wording.
Yeah.
It's not a chart book
No, I follow
type
you.
point at all.
But that's, you say it means as encapsulated in 235, is that right?
Yes.
Yeah.
Yes, indeed.
Well, perhaps be fair to you, I think you say it means that, but you don't have to cross out in constant 1993 prices. You could put in brackets, i.e. or something like that.
Yes, indeed.
Yeah.
It's simply trying to tease out
You-
what
that-
it
you
is.
say
What's
that-
meant by in constant
That's what,
1993
yeah,
prices.
that's what it means, yes.
Come back to
Right, so we're going to 239.
239 on the linguistic point, which this is the first way, I think, in which he deals with this, because he rejects the submission that this construction was faithful to the text. And he does so because, as he says, it would require the revisions set out, I think, in paragraph 235. But that is wrong for the reason I hope that I've just set out.
Yeah.
We're not seeking any revision into
That's what it means.
indeed. The point is then elaborated or repeated in paragraph 240, where the judge says in the first sentence that we're seeking to read in words. We're not. And in 243, he says that it's not open to us to do this, as it's counter, effectively, to the language used. And that appears to be based on his findings at the end of paragraph 240, where he says, last three lines, it's quite clear that what the adjustment provision is there describing is the published index GDP figure in 1993, year of base prices, produced by INDEC using its 1993 year of base price methodology. But that, we would suggest, suffers from two major problems. First, it simply doesn't deal with the use of the defined term actual real GDP, which is there in the denominator, and it's defined in the securities. But secondly, it forgets that there's no such thing as published 1993 year of base prices after a rebasing. And the judge's implication of a term that there should be was because he considered that this denominator wording required it, which of course is the very question which needs to be answered and which the Hubbard deflator addresses. Now, the judge's second reason, we think, is in paragraph 244. In other words, the common ground that the Hubbard deflator is designed to tell you what a 2004 base figure in any particular year would look like in 1993 prices. Now, that's the effect of the construction. And it is only a criticism if it's inconsistent with the language or purpose of the provision, which in our submission, it clearly isn't. Now, the third reason is that set out in paragraph 245, where the judge concludes that the approach doesn't work on subsequent rebasings. But the judge, with all respect to him, was simply wrong with that. It was dealt with in evidence by Professor Hubbard. I've already shown you paragraph 117C of his first report, where he says that it works on a rebasing. And he was cross-examined about it. And perhaps I could just show you briefly that cross-examination at Supplemental Bundle 4, tab 62, page 78. Um,
68, did you say?
I'm sorry, page 78, tab 62, page
Yeah.
78. And if I could pick it up, please, at internal page 47, line 12. And this is part of Professor Hubbard's cross-examination.
I'm so sorry, can you give me that reference again?
Yes, internal page 47, line 12.
Thank you.
Page 78 of the bundle. And he's been asked here about the deflator. And he says, if there is a future rebasing, this is a forensic exercise. I've already told you I wouldn't even be looking at 1993. I'm not sure that's the question. But if you wanted to look at 1993, you could go from some future base year, let's call it 2016, to 2004. And then 2004 back to 1993. You would just be adding a step to what I said before. I can't say if that's part of the Republic's argument, but that is the way you could do it. And then the question says, all right, put it more simply, what do you say index published deflator say for 2017? Let's say for 2017 to 1993, because there isn't one, is there? That's correct, says Professor Hubbard. I said my principle, I'm here as an economist, not as an attorney. So as an economist, I would say that you should always be looking at the real world economy, the most recent rebased numbers. If it's the court view that it needs to be in 1993, I have outlined one way to do it. Then to take your hypothetical, you would just do 2 steps instead of 1. But it's not really the way economists would look at the problem. The questioner says, I understand. So if we're right and the court does require 1993 year base prices, you'd have to add these extra steps because you'd have to restart and you'd have to find a deflator for that new period. So you'd have to add on these extra steps, which are not there, correct? And as Professor Hubbard says, now you've changed the question because you said 1993 year of base prices. That would require 1993 bases. What I'm talking about is 1993 prices for the future basis. If your question is, if you had to have both 1993 basis and prices, if that were your lordship's decision, then yes would be the answer to your question. Now, the judge said it was...
Slightly highlights my question about what is published by way of a deflator. Because he accepts there that there wouldn't be a 2017 published deflator. But if I've understood the equations that Mr. Hubbard uses, he's not talking about a deflator published as such. He's simply using the deflator, which is inherent in the 2 figures which are published for at least the basis years, namely nominal and actual real.
Well, that may be right, as my lady pointed out.
That seems to be what the equation uses. So we're not talking about a separate published deflator. And then I follow the logic of him saying you'll have that for the second base year if there's a rebasing, and you can do it in 2 stages.
Whether that comes from the information that you've identified that is published by INDEC, or whether it comes as a separately published deflator, probably for these purposes doesn't matter. But the point is that Professor Hubbard is clearly making is that if you have a subsequent rebasing, you just do the same point, but you go back to 2004. That's the additional step. So if there is a rebasing such that you've got a new period that you need to take into account, the question is no longer, well, what is 2004 and 1993 prices? The question is, what is 2016 in 1993 prices?
Well, in 2004 prices, and then you do it again.
Yeah, absolutely. Absolutely. My lord has the point quite clearly.
Did Dr. Boyter give any evidence about this?
My lord, I don't think he did. I don't think he was asked about it or volunteered evidence in relation to this, but I will check again whether that is right. And what the judge said in his judgment, as you've seen, was that he thought it was unclear what the additional step would be. But he suggests it's actually quite clear from the evidence. And the reasons that the judge put forward in our submission don't really grapple with this alternative construction. And if we get this far, which of course we say we don't, but if you consider the language forces you to the annual adjustments that the respondents contend for, this construction of the denominator is, we would suggest, consistent with the language. It gives proper effect to the defined terms and fulfills what we say are the clear economic and commercial drivers behind the clause, and should be preferred to the respondent's construction and all the baggage that comes with it.
You haven't submitted that if it meant what the claimant said means, it could simply have said 1993 year of basis prices rather than 1993 constant prices. Is that because that wouldn't work on the definition of YOBP, and therefore you've got to spell out something rather more elaborate in the rubric that the judge has set out as to what your construction amounts to, or your chart book?
Well, in a sense, it wouldn't work on YOBP because that's changed, but working it through to actual real GDP, which is what the denominator focuses on, it wouldn't work there.
Well, it's the... That's right. Thank you.
Sorry, Ben. I'm informed helpfully by Mr. Valentin that both Dr. Borenstein and Dr. Boyter dealt with this in their second reports. It may be unnecessary actually to turn them up now, but just for reference, it's supplemental bundle number 3, tab 48, page 138, where Dr. Borenstein makes the point, which when I said it led to some controversy between different parties as to whether this preserves the growth percentages. But one can see that because you have, certainly when one's looking at Professor Hubbard's figure of 1.60 and you apply it, you're applying that to the fraction. The fraction is then applied, we say, in the way outlined, and does preserve the growth percentages. But
if you're using the New Year's methodology, that of itself skews the growth figures, doesn't it?
Well, what you've taken out is the 1993 year of base prices. You're using 2004 year of base prices. All you're doing by reference to 2004 year of base prices is calibrating it to adjust for inflation. But it may be more convenient. I mean, that is where Professor Borenstein deals with it and says in terms that it produces, it's referred to there as the inflation adjustment method, generates an adjusted base case GDP series that has the same growth rates as those resulting from the table set out in the definition of base case GDP. And that's paragraph 17. I'm told Dr. Boyter deals with this at tab 49.
Yes, page 166.
Indeed. beginning from 165. I don't think it would be wise for me to make submissions to you on this.
Mr. Davies deals with it. 302.
I'm told Mr. Davies also deals with it, and I can see I'm being pulled into a rabbit hole that I don't particularly want to go into at this precise moment. But insofar as this genuinely is an issue that one sees it hasn't been addressed in terms by the judge, if it is, I will come back to it in such time as I have by way of reply. But I'm conscious that I'm already later than I intended to be yesterday.
Yes.
I would solely in mitigation say that I have needed, because of opening the appeal, to go through a number of concepts, and in that sense have done part of the heavy lifting.
Yes, indeed.
But I hope would give me an opportunity, if the court will permit, to have some time for a reply tomorrow.
Yes. One final question from me. If you are right on your ground 4, is the quantum common ground?
Well, I think if we're right on our ground 4, the binary triggers aren't triggered.
That's common ground, that's my question.
That I do not know, but I believe so.
That's right.
It is, I'm told it is.
Yeah.
So unless there's anything else, I can address the court on those our submissions.
Thank you very much, Mr. Railton. Ms. Provisa, do you want 10 minutes now?
I'm happy to start for 10 minutes.
Right, let's start then.
My lords and my lady, we're going to divide up on this side. Mr. Arden, who's sitting behind me, is going to deal with factual matrix and with some of the documents my learned friend went through this morning. I'm going to start with the words, but I want to just say something about the way that Mr. Railton framed the debate yesterday. He said at the outset yesterday that the debate was between the single fixed fraction and the annual fraction. He said that at transcript page 2. But that is, however, just part of the debate and not all of it. What Mr. Railton has to show you is not only that the parties intended to adopt a fixed fraction, but the particular fixed fraction for which the Republic advocates. And we say there is no trace of any such fixed fraction in the securities or any description of how you get to it. And there is an obvious reason for that, we say, which is that it was not intended. It's not some massive oversight. If you were doing that exercise of applying some sort of fixed fraction, we say, and your lordships have made the point to Mr. Railton, there are many ways in which you could get there. For example, you could use an average of the backcasted figures rather than just 1 year, or you could use the year of the new methodology, which is 2004, rather than the last year before the rebasing. The Republic's own witness, Mr. Wright, said in cross-examination, and I'll take you to that in due course, he said the choice was utterly arbitrary. The other thing that Mr. Railton said yesterday at the outset was the complexity of this appeal is in the underlying subject matter and the nature of the securities. That was in transcript page 4. With respect, we don't agree that the outcome does in fact depend on that. Our primary position is that the purchaser of the securities in the market doesn't have to go into all those underlying complexities. They buy the written instrument, which tells you the measurements used and the calculations done using those measurements. And it does so clearly in a way that the Republic accepted before Mr. Justice Picken works as a matter of mechanics. It leads you to a fraction in every year. But if you do go to the complexities, as Mr. Railton does, then we say actually the choice of words and the methods is entirely rational and explicable, and it provides investors with certainty and means that the goalposts of the original bargain are not moved. Fundamentally, what this case is about measurements of GDP and their use in the securities. Now, Mr. Railton has sought tirelessly to make it about some platonic concept of real-world economy. But as Lord Justice Popplewell pointed out this morning, even if that exists at all in some abstract way, the only way it achieves realization in the commercial world is through one or more systems of measurement. And what the securities are directed to is specifying quite carefully and with which different measurements are to be used and when. To use Professor Hubbard's language, which was cited by Mr. Railton yesterday, the securities are loosely tied to the macro economy. But the real question is what estimates or measurements the parties stipulated in their words. So having made those points about the debate, I want to start very quickly with this overview with 3 short points, each of which we say is fatal to and not answered by the Republic's submissions. The first is the importance of the words each and such in the adjustment provision. Your Lordships, if your Lordship will and my lady will turn it up in for bundle 2, tab 15 is where we're looking at it, even though that's the 2010 security, it's at page 36. And the court will be familiar with this by now. But the short point is the parties clearly specified that each year is adjusted by the ratio for such reference year, i.e. the figures for the year being adjusted, not for another year. And this construction reflects the plain and unambiguous words of the adjustment provision. In fact, it is, with respect, the only construction that makes sense of the reading of those words. The words each and such in the adjustment provision are not realistically capable, we say, of any other meaning. And what those words provide unambiguously...
I'm sorry to slow you down.
Sorry.
But just so I can understand, we've got such used 3 different times.
Okay.
The first time it's used, what Mr. Railton says is it's identifying which years in the table are to be adjusted, and it means the figures in the table for each reference year. And such means each such, and I think so far you say you agree with that?
Yeah, well, if you read the adjustment provision and you go to just read it through. If the year of base price is employed by index for determining actual GDP, shall at any time, I'm going to come back to by a calendar year other than the year 1993, then the base case GDP for each reference year, so that's each reference year.
It's 2005 to 2030.
The end of the, yes. Shall be adjusted to reflect any such change, that's the change in the year of base prices, by multiplying the base case GDP for such reference year. So that's what it's pointing out then is that the numerator and the denominator in the adjustment fraction to be applied are based on the actual real GDP for such reference year in the new year of base prices and such reference year in constant 1993 prices. So that is we say, a complete and functioning construction of the adjustment provision.
So if you want to adjust 2029,
yes,
you use actual real GDP for 2029
yes,
and actual real GDP for 2029 in 1993 prices.
yeah,
But you can't do that until you get to 2029 because you don't know what the figures are going to be.
yes.
That's the way you say that's how it works.
But it's how it works, and what you do know, and I think late Justice Falk made the point, you do know the base case GDP figures in the table. So you're going to be making some forecasting anyway, but you do know what's set out in the table. Now the table is very clearly in 1993
So I was only to make the point. It's the second and third use of such that matters to your argument. It's not the such that you get reflect any such change in the year of base price?
No.
'Cause on both your cases,
Yes.
you've got to change everyone in the
Yes,
table.
absolutely.
Sorry, I was just trying to identify that you were at least at one with Mr. Relton on
What we say is that is a complete and functioning construction. And as I said, before Mr. Justice Picken, in opening, Mr. Valentine accepted that it worked in a mechanical sense. The reference to that is in the supplemental bundle 4, tab 58, page 11. And what it doesn't require is any words to be read in. The second point,
Or shall we do the second point in an hour's time?
yes.
Right, 2 o'clock.
Court rise if able.
It's not really. I mean,